Absolutely, Bongi. Well, let's do exactly that, and we give you analysis on Matlala's stop-and-start testimony throughout the day. We're joined now by the legal expert, Advocate Jazz Vilakazi, who's been watching it all. Good evening to you, Advocate. Thank you for your time. In a way, in my mind, I sort of likened today's proceedings to the legal equivalent of deep-level mining. You hew out a ton of ore for an ounce of progress or facts. Much of the day spent on legal points, especially about the application related to Vusimuzi Matlala's invocation of the privilege against self-incrimination. Was this a necessary legal skirmish in the battle for the truth, or was it a diversion, legal strategy at play?
Mr. Simelane, good evening to you and your listeners. Bizarre day indeed, I think, is a good word for it. Insofar as the skirmishes that we saw today, two of them, the one for the adjournment and the hypothetical questions, and then the one regarding legal privilege. Insofar as privilege is concerned, or the right to not incriminate oneself, rather, it would appear as if that is a tactic that is now being used by most visitors or attendees to the commission in particular, on the basis that they do not want to incriminate themselves. But let's not forget, Mr. Matlala was at the commission very recently, and one of the requirements was that he would come back with an affidavit which explains then his positions insofar as privilege is or at least self-incrimination is concerned. It wasn't for him to write up an entire affidavit basically trying to get blanket self-incrimination granted to him, or the right not to self-incriminate.
Yeah, so speaking of that blanket approach then, why did we end up bogged down on this point with this question of when and how the privilege and right against self-incrimination can be evoked? Isn't the law settled on this, both in terms of Section 35 of the Constitution as well as case law? And you heard the case there of the Secretary of the Commission of Inquiry, the Zondo Commission versus Zuma, that case being cited. So one would have thought that the law is pretty much settled, no?
Well, the law is very settled. However, you know, it is the job of a legal practitioner to represent his client to the best of his abilities. And this issue of self-incrimination had been raised before with a few other witnesses. And the Commissioner Madlanga himself, in fact, made it clear, as well as the evidence leaders, that one cannot ask for a blanket immunity, as it were, against answering questions, because according to the Commission's Act, every witness is expected to come to the hearing and answer truthfully. So there was no reason for us to be bogged down. Secondly, the other issue which has always been spoken about by the commissioners is the fact that you cannot refuse to answer a question just because you think it's going to incriminate you. For instance, if somebody asks if I know you, I would have to say I do know you. It is in the detail wherein you could claim this privilege. However, it would appear as if Mr. Matlala and his team decided to claim it from the get-go, as it was.
There's another element, I don't know, perhaps from a legal professional perspective. I don't know if you picked up the dynamic between Mr. Matlala and his legal representatives. The point that was being made at one point, they were saying that if we don't get the postponement of today's hearing, being the advocate Missy, who was representing him today, saying that our instructions are to withdraw, only for him to say, I'm confused, I don't know what that is about, and then them saying they need to you know, confer with him on that point, and then ultimately some are saying the bluff was called by the commission to say, actually, you're not getting a postponement. All the way to the latter part of the commission now in the afternoon about these documents that he says he's got and he will bring tomorrow. And now the legal team needs to confer with him what those documents are, as well as the absence of Advocate van den Heever posing problems for Mr. Matlala. Did you pick up that dynamic there? And what's your understanding of what's happening there?
Well, yes, I suppose the first one is this strong arming tactics that's my view on it, that was employed by the team for Mr. Matlala, in that the counsel for Mr. Matlala immediately went on the offensive this morning, speaking in hypotheticals, but also asking for an adjournment. And whilst trying to speak in these hypotheticals, she also then implies and in fact says it out clear that if they don't get the adjournment, then they would withdraw from the matter on behalf of Mr. Matlala. I think Commissioner Baloyi, in fact, then saw through that and asked directly, confirming whether this was an instruction from Mr. Matlala. They then indicated okay. So it was rather very baffling for us, for Mr. Matlala to come back and say, but I'm not sure what is happening here. Insofar as a withdrawal of a counsel or even attorney is, generally it is a unilateral act. The relationship either doesn't work or there is not enough instruction. However, when one comes to the commission, as indeed when one comes to court and asks for an adjournment, that is not a given, and therefore one must be ready to proceed. So it was a bit of a sad situation to see the council then having to backtrack all the way to Mr. Matlala appears to be confused when she indicated it was quite clear.
All right, let's leave it there for this evening. Thank you for your time and your expertise. That's legal expert there, Advocate Jazz Vilakazi, reflecting on today's proceedings, which, as I said, were something of a labyrinth of legal complexities that played themselves out at the Commission of Inquiry today.